As introduced, my name's Steve Weisbrot. I'm a partner at Angeion Group, which is headquartered in Philadelphia in the United States, but also has offices in London. We are a third party class action notice and claims administration company. We handle everything related to the administrative aspects of a class action, from initial outreach or book building on an opt out case, whether that be in the UK or in the Netherlands, multi jurisdictional, and especially the United States, through claimant verification and ultimately the distribution of funds, whether that be by check, electronic method, or some other means, as well as explaining to the court via notice of administration plan or in-person testimony uh, all of the more administrative aspects of that process. Cam Azari sits in a very similar role. He is an executive vice president of Epiq and the director of Hillsoft Notifications. Cam has more than 20 years of experience in designing and implementing legal notification and claims administration programs, both in the US and abroad. He's been involved in a bunch of high profile cases, including the Takata airbags litigation, the Volkswagen clean diesel litigation, and the BP oil spill disaster. And also of note, he was the author of the proposed notice and administration plan on the Merrick's MasterCard claim that we're all obviously looking at the cat, waiting to see what will come down, which will probably bear on most people's lives who are attending this conference. So Cam's intimately familiar with the UK system, in particular the cat. Scott Hardy, who is also here with us, founded a website called Top Class Actions more than a decade ago. The idea behind his website, which he'll be able to speak to much better than I can, is to connect claimants with lawsuits where they might have an entitlement to make a claim or claim cash. Um, Top Class Actions is the world's most popular group and class action website. It has millions of views per month of people looking for lawsuits and settlements that they might be eligible to participate in. He also recently launched Top Class Actions Canada and Top Class Actions UK with a plan to further expand throughout the group. He knows a tremendous amount about the value of internet and how to connect would-be claimants with the settlements that they may be entitled to. The U.S. obviously being an opt-out jurisdiction becomes increasingly important for the public to have a centralized portal where they can go and see what money they might be entitled to, what claims they might be a part of that they wouldn't otherwise know about. Tom Ball, who's not with us yet, but I understand is just minutes behind, has concentrated his career on effective management efficiencies and strategies at the C level in performing the workflows that are attending to communications intake. In other words, Tom has a huge network of dedicated legal specialists who man 24 hours a day, 7 days a week, 365 days a year call centers. So when class members see the notification that Cam or I have put out as part of the official settlement notice, or that they have learned about on Scott's website, they have someone to call and speak to that's been trained on the intricacies of the case and can speak intelligently. And it also takes the burden off of the law firm, because so often we'll hear, oh, you know what, we have a lot of paralegals at our law firm, just give them the phone number, and then Cam and I will buy television or radio advertising or digital advertising that reaches millions and millions of people, and some are part of the settlement and some aren't, and they end up overflowing the business operations of a law firm. So having someone who understands the best practices, how to get information out of those people quickly, efficiently, and determine whether or not they should move on to next steps, such as filing a claim, or whether they're not eligible under the settlement, becomes increasingly important in planning for your settlement and class aggregation needs. With that said, and my rather long-winded introductions, I'm just going to forecast how we intend to address this panel. First, we're going to talk about book building and client aggregation, and that will really be led by Scott and myself as the different strategies that we're seeing used successfully. Then Tom, as long as he's here, will jump in and talk about those best practices for intake. And then Cam will lead us on a discussion of best practices in legal notification. What should the notices look like? What information is essential? How do we decide whether we're going to mail to these two potential claimants, email to them, both? How do we determine what media they read or visit? And how does that all come together to assure the court that we're providing reasonable notice to people who deserve it? Because quite often, by the time you are in a settlement posture, the parties are aligned in wanting that settlement to go through. So they really need a third-party expert like Cam to come in and verify that their plans aren't just a gesture, aren't just made so that their legal fees can get approved, are actually doing the right thing. And that's where testifying experts like myself and like Cam come into play. So with that, I'm going to kick it over to Scott, who can tell us about top class actions and how that typically interplays with class members and its value. So Scott, if you'll unmute yourself and jump in, we'd love to hear from you.
Thanks, Steve. I appreciate the introduction. So I started Top Class Actions, just like you said, to help connect consumers all over the world. And so we created these lawsuits and settlements to help connect people around the world to what they otherwise wouldn't know about. And we publish, and now we actually follow these lawsuits that are being filed in the UK from the moment they're filed to as they're trying to build this book of clients and claimants until they're eventually going to pay out. And so if you go to uk.topclassactions.com, you can actually see all the different lawsuits that we're following. We're sending people out to different law firms that are currently aggregating claims. And we're doing our best to connect to these consumers out there, because most people still don't know about mass actions, group actions, class actions. And so a lot of what we do is just educating the average consumer so they know what their options are.
No, that's great. And we see here in the States, where Scott's business is a lot more mature, that when he sends out his newsletters on cases that are already settled, we will see a noticeable increase in claims on those days, because he has essentially a group of people that he has access to that we know are predisposed to make claims if they otherwise qualify. Some people might call them litigious. Some people might call them just consumer rights advocates. But the bottom line is they do follow his site, and we do see on the administrative side that I run, when his newsletter goes out, I'm aware of it because we see a noticeable uptick in claims. I will add that Scott's method is one way of aggregating claims. However, particularly in the UK, and then also in the EU on cases that are being filed under the Stichting model, under the new regime, and even the previous regime, the 305A, that in addition to that, there are a lot of other tricks of the trade and media methodologies that are available to attorneys looking to build a book of claimants. Primarily, these are in the form of paid media, and they are really important in that you are creating a direct link between the consumer and the attorneys who are looking to find out if people have been harmed and in which way they've been harmed. For instance, we are working right now on behalf of a stichting called the Diesel Emissions Justice Foundation in the Netherlands that is seeking to aggregate claimants for 3 different groups of car manufacturers that are alleged to have violated emissions laws by using what has been alleged to be a defeat device. And we are using a variety of different media, but primarily in that case, it has been a lot of social media and a lot of digital media, which presents challenges because of the pan-European nature of the media. It's not like it is in America, where we need to worry about primarily one language. There are occasions where we'll use two or three just based on the known demographics of the class members. But in that case, we had to set up a system where we could advertise in virtually every major European language, and more than that, be able to intake the documents. And Tom Ball is going to talk to us a little bit about this in just a minute, and review those documents for eligibility in a number of different languages to make sure that people who are making claims are verified claimants, did own the subject vehicles, did own them during the right time period, and have legal title to them. These are all things that a claimants group is going to need to be able to prove to a defendant. We also take great care, and I think that Cam will speak about this later in the context of the court ordered notice, but to understand the demographics and the psychographics of those people we're trying to reach. We're not going to use the same type of media to reach a young group of car owners as we might to reach people who have been shorted on a life insurance policy, for instance, a faulty mortality rate, or a securities case. We know that the same people who read the New York Times or one of the more sophisticated papers are not the same people who read the Metro. People who are going to certain websites in order to learn about food and wine are not the same people who are going to race car websites. And sometimes there is overlap. But the point is that when you hire a reputable company, whether it's my company or Epiq or one of the other companies in the space, they're going to have access to very sophisticated data, syndicated media services that are really the same services that 95% of commercial media buying and planning agencies are using to evaluate who they're reaching and the best way to reach them. And I'll let Cam talk you through a lot of that later. But the point I wanted to drive home is that it's a very integrated media plan when you're going out trying to aggregate a book. That also often involves third-party PR outreach, penning of op-eds, consumer surveys. This isn't throwing spaghetti at the wall and seeing what sticks.
Steve,
Yes.
Steve, can I ask you a question? So, top class actions, our model is we get all these people signed up. So we've got, 1 million people on our newsletter, follow us on Facebook. And as you said, when we put out a message, we get a big reaction. So from your experience with the diesel emissions cases and the emissions cases that you're working right now with that Stichting, are you seeing more of a response from traditional media, like, the billboards, radio, newspaper? Are you seeing a more of a response from your pay-per-click advertising online?
No, I think it's a really good question, and I think that there's a synergistic effect there. I will tell you this: we are having tremendous results on the digital and social side. That's been very strong, but some of our not some of our strongest days are the days where we have earned media, where there are newspaper stories about the effort, and that will then drive people to search for the Stichting online. And we can see that's happening because we're monitoring the search traffic, how many times the particular keywords are entered in, Stichting, diesel emissions, Volkswagen case, etc. And it's always been our experience that when there's earned media, we see about a 30% uptick in organic search activity. But in that particular case, there was a very sophisticated PR strategy that we laid out, including doing press conferences at places like the Car Museum in Belgium, so that there was a contextual connection between the messaging and the place where the messaging was coming from. And it was very well attended by reporters all over Europe, as well as local reporters. Interviews were being done in Dutch, in Flemish, in French, and the news really was fused and spread so far and wide that on a day like that, our numbers those were our best days. But on an average day, we see paper, the pay-per-click as being incredibly important, but we look at the whole funnel. And if that's a term you're not familiar with, there's a marketing funnel that sort of starts with awareness, so letting people know this exists, all the way down to conversion. So what you really want to do is you want to make sure that you're touching all of those different areas of the funnel and pushing the consumer along that funnel to give them the information they need to make an informed decision. But with that said, I see that Tom has now joined us. Tom, you missed my introduction of you, but I assure you I said very nice things and shared with our audience the length of your business and how you are really the expert on intake 24 hours a day, 7 days a week, and how you're able to help attorneys offload so much of that administrative burden. And I think just giving our audience a brief glimpse into the realities of that world and how you can help would be of great value to everyone.
All right. Thank you, Steve. Well, I mean, it's a...
Tom, you're muted. Okay.
Yeah. So it's basically a fairly complex issue to actually dial in the intake and actually work on that. So what we find basically is that in these phases, there's the kind of pre-litigation phase on the intake, and that can be screening criteria that's dialed in, and we pass that in our system. So, the yes/no questions are actually moving through. But as a litigation may move forward, you may change that intake. So you have to be nimble to be able to actually, as you learn about the case and as it evolves, making sure that you are ready to actually change that, and you have advisors that are actually doing that. And what we actually do is map that and then change it. And then when you get into the settlement phase, it may change again. Because there's a short time period and the qualification gets more critical. But I think even more important than even all that is just the time to respond. If you're really going to be doing a serious investment into the marketing side of this, which is going to be the majority of the cost, the intake basically needs to be covered in a 24/7 level. And that means that there's a consumer and what they expect from this and how they expect to be responded to, that you have to have a team to be able to do. So a 24/7 team, just to build that out is pretty significant. So if a law firm is going to go out and actually proceed with something like this and have a significant investment into the marketing, they want to make sure that they can actually respond to the phone calls in about 3 rings or less. That's what consumers expect. On 4th, 5th, and 6th rings, they start to get abandoned calls. And also in the digital lead world, what you really have is about 1 to 3 minutes to respond, or they start to search for other ways to get information. And so what you need to have combined in there is automation, which is the ability to text people if they respond to you on a web form, saying that you're going to call them, and then a live call go out, and even email them. And generally, just statistically, since we do millions of these intakes per year, you're only going to reach these people 37 to 40% of the time on the first call or the first reach out, regardless, on a web lead. So in a web form submission, I think what you have to do then is have a multiple attempt process and a tasking and software in place to be able to hit them if they call at 10 a.m. and you leave a voice message, for them to be able to call you back, be able to track that, and then task to call them back at 6 p.m., to call them on weekends, to call them on holidays, to be able to convert that. So being ready for the investment is really looking at the intake. So in all business, really, you have 3 pieces. In all business, you really have the product itself. And the product here basically is what the litigation is, or the class action is, but the law firm themselves is really the product. And then what you basically have is marketing, and then you have intake, which in the rest of the world is called sales. And you can't drop the ball yet, or you just basically squander your entire return on investment on the front end. So those are a couple comments about that. But being ready with your CRM, being ready with case management software, being ready with managers to manage the process, and really kind of getting a projection of what the volume of lead flow and the volume of calls inbound are going to be. And also understanding that 24/7 inbound call response is far different than inbound web response. Being able to pick up the phone and people not being on hold, being able to respond to them is a significant undertaking if you plan on marketing like that. What usually yeah, go ahead.
I'd be curious if you saw any meaningful trends or changes in terms of in terms of consumer expectations during the lockdown, during COVID, anything that people can take away that you've seen, obviously dealing with millions of people a day?
Well, and in some ways, it's been easier to reach people because there are more people at home and everybody's working from home. In some ways, it's easier. However, in the web lead response, it's just different. And I think what, I will look at reports on marketing in this, like even from HubSpot. The data just basically shows the people that really turned customer service on their ear and changed it for everybody was Amazon. And what people now expect is that type of service level coming through, even on marketing campaigns like this. They want a response. They want it right now. And you also have to create multiple ways to communicate with people now. So what we have seen basically during COVID-19 is the data almost comes out similar, but in some campaigns, it's easier to reach people now that almost everybody's working at home than it was at work. We didn't have to wait as much to get them. There's other times of the day to reach them. So if they fill out a web form during the day before when they were at work, they may not want you to call them till 6 or 7 o'clock at night because they just wanted to get the web form submission in. Now you may get them, all right? But then things have changed in other places. At nighttime and weekends, they may be trying to get out and so forth. So things have changed. So the answer is yes, a lot has changed, but the consumer expectation is still very critical. What they're expecting is what the new consumer expects based upon customer service and response time.
That's interesting. I just want to take a moment to remind the viewers that we are very happy to answer any questions that you all have. You could just type them directly into the chat, and everyone here likes a hot panel. We're used to being in front of judges and juries, and we'd love to answer any of your questions. Tom, if it's all right with you, I was going to kick it over to Cam now to talk about all the things I discussed, but maybe Cam, if you could start with, in theory, the difference conceptually between sort of a court-ordered notification program involved with a case as it is distinct from a book build or a client aggregation plan, I think would be a good place to start, because I think in a lot of people's minds, they're really two sides of the same coin, and I'd be curious if that's how you saw it.
Sure. Thanks, Steve. And I appreciate speaking later in the panel because my neighbor was running a leaf blower until just now, so this is great. So thank you. So yeah, I mean, taking a step back for a second, I think, what's interesting about this panel, we've all been looking every day, did the merits decision come down? Did the merits decision come down? Because we want to know, we're really dealing with almost a blank slate here in the UK. The reason that you've got 4 Americans talking to you on this panel is because we've been doing this we've got 25 or 30 years of jurisprudence in the United States on class action notice and claims administration. And in the UK, it's almost a blank slate. So, what we've done, we're not any smarter than anybody else. We've just done it a lot of times, and that's why we've been consulted to come in and talk about these things. Now, in terms of the break between book building and the actual legal notice, in the United States, legal notice for a long time, the goal of the legal notice campaign was to demonstrate to the court that everybody in the class had a reasonable opportunity to see the notice and participate. You wanted to be able to come back and say, we're reaching, which is the term that we use, a certain percentage of the class, typically 70, 80, 90% of the class, to say to the court, look, Your Honor, we gave everybody a chance to see the notice and participate. And in the States, that the focus has shifted, especially dramatically over the last 5 years, in my opinion, from we still want to give people a chance, but now we really want people to respond. It's critical that we get people to respond. File a claim is the key. And that has become, frankly, more of the criteria for which notice plans are being evaluated. So the book building piece is actually much similar to what I think the more recent trend is with notice. When you're really trying to target people, like what Scott and Tom do, what Scott does especially, really trying to target people, build this core audience of people that are going to respond and participate and be interested, and get them to respond. And so on the notice side, we still, when we're coming into the court, in the United States, it's at the class certification phase, or sometimes it's settlement when the class is being certified at the same time. And in the UK, if it's under the competition rules, it's what we call the Rule 81 notice, where we're giving people the opportunity to opt out if they're in the UK, or opt in if they're in other jurisdictions. That's the phase where we are doing a broader notice And we're wanting to be able to tell the court, look, we gave everybody a chance to participate. And then later on in the process, if you get to a settlement or a judgment, the Rule 91 phase, that's when, frankly, we're doing a notice again that A, we're wanting to give everybody a shot, but B, we're wanting to really, I think, behave like Scott is behaving in doing a very targeted, extremely targeted media plan to get people who are likely to participate and file claims. I don't know, Steve, what you think about that.
No, I think that's entirely right. It used to be entirely opportunity based, and that's what Cam and I would testify to the court. We would say that, this percentage of the class had the opportunity to participate, and this is the approximate number of times they had that opportunity. Now the judges are saying more and more in the United States, yeah, but how many people did participate? And listen, there's a lot of things that can affect participation, right? They may not have liked the settlement. They may have thought it was not enough money and they didn't participate. But Cam's right. And especially in the CAT, when you're moving to sort of that post CPO notice, that settlement notice, and you're trying to aggregate claims, and you are doing exactly what is being done during the book build phase. I'll throw one back at you, Cam, and ask you how in a number of European countries, and in particular in the UK, where group actions are such a new thing, and we not even all citizens are familiar with them. Do you have any advice for the practitioners in terms of messaging, or should it look very similar to what we've been doing in the US?
Well, yeah, I do. I mean, on the Merrick's case and on a couple of other projects that we've consulted that are still, the other projects are still waiting for Merrick's to come down before they decide what they're going to do. We've really stressed the importance of PR in the UK. It's not that it's not important in the United States, but we've found it incredibly important to team with we're an American company. We know how to do this, but we don't have the boots on the ground relationships with the press in London and in the greater United Kingdom. And we think it's critically important to be partnering with an experienced local firm to be able to get a message out and a buzz among the local press, because this is a new thing. It's newsworthy. In the United States, class actions are filed every single day. There's notices going out every day. You can't open up a magazine or a newspaper or go onto a website without seeing a class action notice. It can become overwhelming a lot of times. But this is the new thing and it's fresh in the UK. And so there's a real opportunity to leverage the press. And so I think that's incredibly important in terms of the rest of you guys think.
If I could cut in there, because it's interesting that you mentioned that, Steve. When we launched TCA Canada and we were doing an investigation targeting it's inhumanely sourced fur that was on these jackets. And these are very, very expensive down jackets. And on the labels, it said these are humanely sourced, but unfortunately it wasn't. These animals weren't killed in a humane way. And so we were reaching out to our friends up north and saying, hey, if you bought this jacket, please make sure to submit your information. We're trying to hold this company accountable. And how the tone of the message is portrayed is so important, because we were getting slammed by a lot of these people when we were doing some advertising that were like, what do we care? These are varmints. These are annoyances. We don't care. We're hunting these. I don't care if they were humanely killed. And so then we had to adjust not only the message of our advertising, but our market, right? So we all of a sudden we said, okay, we're putting out these ads. Let's make sure we put them out to people who are members of PETA. Let's make sure that we're putting out to members who are more liberal and aren't hunters and farmers. Mm-hmm. And doing that same thing now in the UK, where people are saying exactly what you guys are talking about, Ken and Steve, is that they're not litigious. We're like saying, we don't want to sue. We don't necessarily want to have that big, the big Americans coming in here and brash and trying to start clogging the courts with lawsuits. And we're having to make sure that we're adjusting our messaging and educating people to say that we're here to help you. We're not bashing these defendants. We're not saying, this is, that they're bad people, they're bad companies. We're just saying that, we want to make sure that you as the consumer get a little bit of justice here.
And Scott, that I think this is where Steve was going with the question he asked me, that ties into the message, right? It's critically important that the message is something that's going to be easily understood and appealing to the audience. It took us in the United States a long time to figure out not to put Latin in notices and big words and, the cut and paste from the settlement agreement, 75-word paragraph or sentences and things like that. It's very important that the notices are drafted in plain language, especially the online pieces, the stuff that's really just 20 to 40 words, have to be crafted in a way that we're going to let people understand what's at issue and make it appealing to them and get them to the websites that we have set up so they can get more detailed information and find what they need. It's really important that the lawyers, calm down a little bit and get the lawyer words out of it. I mean, I'm a lawyer too. I understand. We have to get the message right, but it's really important that we understand our audience. Aren't always on the same level in terms of complexity.
I think both of those points are really sage. The other obstacle that we find ourselves dealing with in Europe that we don't typically find ourselves dealing with in the United States is an extreme sense of brand loyalty to certain brands, brands that are considered homegrown successes, let's say. And, without mentioning any particular brand, we were running a book build campaign where we were seeking clients against a well-loved brand, and we were getting really nasty responses. How could you be trying to put this company out of business? They've done so well for us, and it was a luxury brand. And when we changed the messaging, not even the messaging, when we changed the picture to depict the luxury element of the brand as opposed to the more pedestrian element of the brand, our rate of click-throughs and signups increased threefold, which was shocking. We didn't change a word. We just changed the picture to remind everyone that this brand may be a local favorite, but they've also made plenty of money and are doing just fine financially. And that one little tweak was able to generate significantly more interest in the client base. And that actually just leads me to another point that I probably should have mentioned earlier. One of the great things about how notice in the United States has evolved and where it's starting from in the UK and the rest of Europe is with such a emphasis on the use of digital and social media. And that it's really important for reasons like I just explained, like, yes, we can target much better. Data is the new oil. There's plenty of data out there. Of course, we're all cognizant of and have taken advice of counsel on GDPR requirements, or in the UK, also PECR requirements. We're aware of all of the and the SRA's regs, all of the things that govern what we can and what we cannot say. But what we're able to do is monitor performance in real time, which you weren't able to do 10, 15, 20 years ago when you were taking out an ad in the Telegraph. Had we not used that right image, that would have been wasted money. But now, 2 or 3 days in, as we see the comments, as we see the lack of performance, we were able to identify there's an issue here, go back to our team, talk it through, work with local experts. Like Cam said, we have PR firms in virtually every country in Europe that we work with when we're doing a book build or an administration program there, figure out what the problem was, and we turned it around. So that wouldn't have been possible but for the use of the right type of media. And I think it's important, as Cam says, that we are starting with a blank slate. In the United States, by contrast, there were amendments to Rule 23, which is the rule that governs class action, and Rule 23C in particular governs the notification of class members in this context. And only as late as 2018 was the use of electronic means to notify class members formally codified as an acceptable way of giving notice. So, while we were years ahead in terms of having a more developed system, we're really just at about the same place in terms of methodology and where we're starting. And it's very interesting. It's very interesting. Cam, any thoughts on that?
Well, yeah, it raises another point. I mean, with the book building piece, we have some flexibility, but once we're using the example of the competition rules, we're on Merrick's, we were required to go in with a really detailed notice and administration plan. It does like 50 pages long, saying everything we were going to do on notice precisely, all the way through the end of the case, which, frankly, was a little ridiculous because the world, I think we can all sympathize with where we are today. The world can change quickly on how things are done, how media is consumed. And so I think it's critically important that in the notice plan piece, especially as you're just saying, Steve, there's some flexibility built in. I get we'll have a budget and we're going to do the same sort of scheme of this, this much digital on these outlets and this much print, whatever. But we have to have some flexibility, especially in the message, like you said, so we can respond and learn as we go along to have greater effectiveness.
Yeah, and I wanted to chime in here real quick too on the those concerns that you're having on the reaching out to the base of people are the things you have to prepare your people for when they get through that to your people when they start to talk to them on the phone. So when you're actually putting together your team to actually do the intake and go through the scripting, you have to have those, I would say, call them rebuttals in place so your people won't stumble. So in those type of situations, if people are going to walk down and they have concerns about legitimacy or anything about what they're doing or any concerns at all of those need to be passed into a system so you can really answer their questions, just so you don't fumble the client at that point. And that just takes some time, so really, that kind of what I would call a charrette needs to be put together where every single possible scenario and question that could come up from the other side is actually put into a questionnaire so they're ready to be prepared on the intake side.
Important that when you're doing these advertising campaigns and you're doing it through social media, you have to remember that you really want to narrowly target your exact consumer that you're going after, because people on social media will argue to argue. They don't, if that's what we found when we're running all these different ads, is that people will sit there, they didn't buy the product, they have no connection to it, but they're just, as Steve mentioned, they're brand loyal. And so what are you talking about? How are you doing this? Because it's social media. People are just happy to go ahead and find something to complain about and go and argue about it. And so if you don't have your audience very narrowly targeted, you're going to be flashing out that message to people that could just be disruptive and start leaving bad reviews on your law firm. They could be leaving you bad reviews on Facebook. And making sure that messaging is on point, and as you guys said, adapting as you go is critical to being successful.
I think another point that's a really welcome distinction for me between the US and the UK and the EU to another extent is that in the US, it tends to be a lot more lawyer driven in terms of who are the face of some of these campaigns. Whereas in the UK, the named plaintiff isn't just some guy who called up and asked to sue a company. It's someone who has a connection to the industry typically, that's been personally aggrieved, that might have been a captain or a titan of finance in that industry. It's all very particular, and that becomes sort of the spokesperson or the branding surrounding the entire campaign. And I think it's really smart, and it also gives people like all of us on this panel a lot more to work with. In cases where you don't have a lead plaintiff that wants that role, but still at least the media facing role, I've seen a lot of campaigns successfully hire paid spokespeople, which is by law not permissible in the United States. You cannot do that. There's some disclosures. You can get there are ways around it, but by law and by circumstance, it's almost never done. Whereas here, it really helps the consumer get more comfortable with the idea of the litigation if there's a trusted face around the brand. And it's something that I've enjoyed working with a number of different firms on, helping to find and source the appropriate spokesperson. And again, that's usually done in consultation with a local PR firm, not just because they have the connections to those types of influencers or celebrities, but because they can give boots on the ground insight as to how those people are likely to be perceived by the local audience. And it's just another distinction worth mentioning. And I do think that I think the language was from Merrick's, where there was a concern about American-style class action excesses coming to bear. And I don't see, as of yet, any of the more frivolous type cases that the U.S. has brought. And my personal take on that, although it's a bit outside the scope of this panel, is that the U.K. still has a loser pays regime. And the advent of the having to incur after the event insurance as a cost and then amortize that over the quantum of each claimant's recovery keeps the more questionable cases at bay. And I strongly query if there were something similar, not that I'm endorsing it, but I query if there were something similar in the United States, might the litigation reputation of class action practitioners change? With that, I really want to again urge the audience, if there are any questions at this point, we would be so pleased to take them. If not, I'm sure everyone on this audience, on this panel, has plenty more to say on all of these topics, but I just want to open it up for a minute. If you were going to type a question, now would really be an excellent time.
And Steve, while we're waiting for questions, one thing we didn't talk about at all, and it's the subject for a whole panel, we talked about media notice, but we mail notice, we send notice by post, and email notice as well. And I think I get a lot of questions about email notice and the efficacy of it. And it's an interesting topic. I don't know how you feel. I mean, we have clients say, "Well, you've got emails. Email is great. Email is better than print. Better than post mail." And there are situations where, of course, email can be, but I just got to be honest, we get better response rates where we do physical mail as opposed to an email. Not in every case, right? Because emails are different depending on how they were collected. But
yeah.
It's important to remember that we can't just assume email is better all the time, even though it's much less expensive, of course.
So a couple things on that point. One, I agree with you. In general, we see better results from mailed notice, but I think that there is a definite relationship between the way a defendant communicates with a potential claimant in a case. If they are used to receiving email, if it's a young demographic, if it was a data breach of a music service company or something like that, and there's email back and forth, email is going to be more effective there. On the flip side, if it's something involving a complex financial instrument or a securities, no one's expecting an email about that. They deal with their broker via post. But what I did want to say is email isn't just email anymore. And I think this is an important point. It used to be that the value of an email was that you could send a batch email to someone notifying them of a settlement or trying to get them to join a pending lawsuit. But now email, provided you have the right opt-ins under GDPR, can be used to identify people on social media. It can be used to figure out what IP addresses people are using on their computers and serve them ads while they're looking at something that has nothing to do with the class action, because we know they've expressed an interest because we have their email addresses. But you have to be super careful about navigating all of the applicable statutes, making sure you have an audit trail, making sure that they've opted in to receive those types of communication. So while that's an arrow in the quiver that we like to use a lot in the United States, that doesn't have a nationalized privacy protection program the same way we see abroad, if you can get those emails with the appropriate permissions, in addition to just using them to email people, there's a lot of other ways to use that data.
Yeah, it's another data point for us, that's right. So Steve, I think we're probably, are we almost out of time?
We are. I just want to take 30 seconds real quickly to Ariel Flavian, the chairman, had asked me just to talk about the fact that we can use email also to distribute monies. And that's across all jurisdictions and across a variety of different platforms, such as PayPal, Zelle, eChecks, etc. And if you can have people opt in and provide their email information, you can then distribute money to them, which is a cost savings method, not just by just having to send it cheaper than a check and not put a postage stamp on it, but also because we don't have to then deal with returned undelivered mail and sort that and do further address changes to find out where those people move to. If you have an email address, that tends to stick with you and is a really, really great way of distributing money. And just wanted to end on that point. But Cam's right, we are running short on time. So unless there are any questions, which we would love to answer, on behalf of the entire panel, I thank you for your time here this morning. It's been a pleasure to address you.
Thank you. Thanks, Steve.